No, I'm not saying set aside the zero tolerance, but I'm saying that I think that some of the resistance that has affected both victims' willingness to use complaint systems or even to approach persons to seek redress after they have suffered instances of bullying or sexual harassment, comes from the sense that it is going to polarize people, that it is going to mark them or besmirch them in some way, as much as the accusation might do so against someone else, and that kind of escalates the conflict. And so, if everybody instead, I think, focuses on the rights to not harm others and oneself to be encompassed in a more healthy environment, that more positive framework may help to eradicate and go along with the zero tolerance, while as well reducing some of the difficulties that seem to surround.
So sequentially, it looks like that we should put the positive environment part of the agenda first, and it's with that positive environment agenda that the zero tolerance policy comes as a last resort piece, that okay, this is what we want you to do, but if anybody is going to cross the line, then it's not going to be tolerated. If I get you.
Yes.
I think that's
so that's clearly a violation of the social norm.
Is there anything that you can recommend that we could look at as a way of putting in place that sort of a policy for both parts? For the positive agenda part, as well as for examples of what people did which demonstrated zero tolerance.
I don't think I can.
Nothing. I mean, this will be something. I suppose it is something we'll have to evolve bottom up, sort of. It looks.
I think it's very helpful to intercede, at a sort of grassroots level as rapidly as possible after things arise, rather than wait.
Okay. Don't wait for complaints and things.
Exactly, and I think also that a lot of informal mechanisms to try to address these issues may work better than formal ones, because then people are unlikely to be caught in the posturing that often comes with traditional adversarial processes.
It's the same point you made about divisiveness. That would be, I suppose, minimized if we go the informal route.
That's right. And so instead of classifying everyone so that there are schisms between who are the sort of in-group, out-group members in the social community, make it more inclusive, and then hopefully some of the community constraints will apply, whether they're coming from staff and faculty or other students in the situation who may become much more self-policing.
Yeah, thank you so much. It's like interesting that most of our sexual harassment law in the first instance came in as a set of guidelines from our Supreme Court. And that held the field for, well on almost 20 odd years. And the legislation is a much more recent entrant. And the legislation in some ways has reiterated what the court was saying, but it has also made its own changes. And we've had, and the reason why I'm giving you this as information, because it has a connect to the manner in which we do law reform in this country, as well as what kind of a role a school like ours, if we are universities of law, we are not general universities, we are single discipline universities which draw from other disciplines, but are still known, and our primary focus is meant to be law. So, and it was in that connection that when this changeover from the Supreme Court guidelines to the legislation came, there was some body of consultation. People had a lot of inputs to give on what their own experience of implementing and running the Supreme Court guidelines had been. various universities, various institutions develop their whole, their own kind of internal codes. But we've not really had a very systematic study of how that played out, what was the kind of evidence of what worked and what did not work in the Supreme Court guidelines. It was a kind of an ad hoc venture, where things from various places, some got picked up, some got dropped. And I'm leading all this up to the fact that we have in the country a law commission, and a law commission gets constituted or reconstituted every 3 years or so. We do not have a statute. The law commission is not a statutory body. It's kind of constituted by executive notification every few years. Generally, a retired judge of the Supreme Court of India is the chair of the law commission. Occasionally you had other people, but that's the way it goes. What I'm leading up to, Jane, is this, that looking at, say, the experience we've had with the sexual harassment guidelines, and looking at the fact that large part of our conversation is about how do we promote empirical based legal studies in this country, how do you think we as a law school should interact with our law commission? Our law commission, as one additional piece of information, our law commission generally operates on 2 levels. Sometimes they take up issues suo motu, they feel this is something that they should research upon and advise the government. Very often the government gives them a term of reference and asks them to research on it. Very often they also sort of send out a very standard form questionnaire to all who they consider to be stakeholders on a questionnaire. So that your response to the commission has to be in relation to that questionnaire. And that's the manner in which the commission has been operating. A lot of its reports have influenced legislation sometimes, have influenced policy, courts tend to refer to them and all of that. At the same time, this evidence-based or empirical-based legal studies that you're speaking about is not the driving force of the law commission. So my question to you with that long prefatory is, what should be the way in which we should start to interact? Because I feel if the law commission takes a lead in this whole area, it might give a fillip to empirical based legal studies of a very different order than if only we as a law school were to do it. So what sort of, are there models, are there arguments, are things that we can draw from on the strength of which we could set up a conversation with the law commission? I'm primarily wanting to get that comparative understanding so that whatever relationship we try to forge is evidence-based.
Okay, well, I think it's a very interesting question and a great opportunity to consider the relationship between the university and the law commission as well. So, I mean, I think it's wonderful that there is a law commission. I was very thrilled when I moved to Australia to find such institutes because I wasn't familiar with them because they don't exist in the same way in the United States. But in Australia we have national as well as state-based law reform commissions, they're called. And I think that varying by state, the different commissions have either closer or more distant relationships with the universities. And so, for example, in Tasmania, that state's law reform commission is actually housed in the law school. And so, that's really a model of a very proximate relationship that seems to work especially well in that state. And I think what it has spurred as a result is some situations where some very unique research to inform some of the initiatives gets done by some of the Tasmanian law faculty. So I think it's a great idea if there's more interaction with law commissions and academics quite often, in addition to some of the retired judges or still sitting judges who serve on ours, there are a number of academics who are appointed as part-time or full-time commissioners to lead some of the research activities. And so I think, you know, one model to think about is having more formal ways that engagement can be developed, so that there might be spaces on a committee of commissioners that include some slots dedicated for academics to participate for a certain amount of time, really to encourage that closer bridge between the academy and between the practice and the guidance to reform it. But a trend that certainly has been very clear in New South Wales, in my state, is that our state Law Reform Commission has, over the past decade, really shifted its emphasis to be much more embracing of evidence-based initiatives and reforms. And sometimes when a reference comes in, there's a fairly short timeline associated with it, and it's not possible to do original research and go out and gather data to answer a question that might be posed. But nonetheless, our Law Reform Commission has engaged with academics to try to compile systematic reviews of the literature, and particularly going outside of the standard legal literature, not just looking